Good morning, a very warm welcome to our webinar on MiCA and the way ahead to you on a Monday. I'm joined today by two colleagues. I'm very happy that both could join me. We have Carmen Redmann-Wippel from our Vienna office and Miroslav Turic from our Frankfurt office. Carmen is counsel in Vienna and specialized in banking and finance. And we are very lucky that she can also step in when it is about regulatory requirements and the new regulatory framework. And she will give us a few also from an Austrian perspective. So thank you, Carmen, for joining. And Miroslav might be known to many of you. Probably we have done several MiCA webinars in the past. He is specialized in financial regulatory law and fintech business cases, and also has a lot of love for all the technical developments in the financial market. So therefore, he also is an expert on MiCA. My name is Verena Ritter-Döring. I'm heading the financial regulatory group here in Frankfurt. And I also have to keep up with the developments. And MiCA is one hot topic at the moment. So, of course, here we are. Just before we start, some technical things. You can see on your lower right side, there is a question button. Please feel free to ask questions during the webinar. We have allocated a little bit of time in the end, and we will answer the questions in the end. And if it's about some understanding, we can also answer the question in between. Only we three will see the question, so it's kind of anonymous to everyone else. So please feel free to make use of this to get the most out of it. We will send you the link to the recording afterwards. If you also want the presentation, please send us an email, and we will. You can have it as well. So let's start. So we have only 4 agenda points today. I will give you a little bit of an overview while we have MiCA, when it will get started. Then we will give you a little bit of the content of MiCA, an overview on that, and I think this is the most interesting part is about the developments in Germany and Austria, and then some practical considerations, as always, in the end. Of course, you are probably all familiar with MiCA. All of MiCA will enter into force at the end of this year. But what was the starting point? Let's think about this. We had a very at the moment as well, we have a very fragmented regulatory landscape. No harmonized regulatory framework in the EU on crypto assets. Crypto assets that can come in different shapes, can be financial instruments, can be securities, can be structured deposits, can even be e-money. So this really depends. And this is not a very satisfying landscape for setting up a business around crypto assets in Europe. So we have a little bit of harmonization that came out of the AML directive, the 5th one. This was already 4 years ago, so in January 2020. The AML directive suggested that virtual asset service providers have to comply with AML requirements in each member state, where they are in the member state where they're incorporated. So this was something, the starting point of a harmonization, but it was only about AML and not really about the crypto assets as such. So, and now you can also see here in this, in our landscape, still lots is blue, so very fragmented. Germany, for example, we have our own national regulatory framework for crypto asset service providers. Sorry, we have Kryptoverwahrgeschäft. Yeah, this also doesn't help actually for European business setup, and then others, have just applied the AML requirements. So as you can see, not satisfying at all. So it's good that we now have MiCA regulation and a single European regulatory framework for crypto assets, which are really crypto assets and which do not fall under the other qualifications I just mentioned, such as financial instruments, deposits, securities, e-money, structured deposits. So because they are already covered from MiFID, EMD, also with CRR. So now we have clarity on how to deal with crypto assets on an EU level. What is a crypto asset? We also included this here. It's a digital representation of value or rights that is able to be transferred and stored electronically, used distributed ledger technology or something similar. So I think we are all quite familiar with this definition. It's quite broad, as you can see, and it captures a lot of, such as virtual currencies, some payment instruments, utility, and hybrid tokens as well, and payment tokens, of course, as well. So MiCA already entered into force 9th of June in 2023. But as always in the EU, it takes a while that it also applies. And we have two phases. We have the rules on stable coins already starting this June, and half a year later, we have then the whole of MiCA enter into force. So, and now I give over to Carmen, I think.
Yes, thank you so much also for the nice introduction. So it's a pleasure to be here also from Vienna and participate in the webinar organized by Telewesting Germany. And I may start now with giving you an overview of what is actually covered by the MiCA framework. So in general, there are 4 sections. On the one hand, MiCA introduced a common taxonomy of crypto assets, so what falls within the scope of MiCA and what doesn't. Then there are dedicated rules for public offerings of crypto assets in the EU and to EU citizens. There is also a harmonized authorization framework for crypto asset service providers. And fourthly, there are bespoke, a little bit also stricter rules for stablecoins in order to maintain financial stability. When it comes to taxonomy of crypto assets, we already heard from Verena that there is generally a super broad definition of crypto assets. However, in order to be able to apply specific rules to certain buckets, the assets are divided into 3 categories. On the one hand, we have asset reference tokens. Those are crypto assets that maintain their value by being linked to either several fiat currencies or one or several commodities or even other crypto assets or a bucket of those. Then secondly, we have e-money tokens. Those are crypto assets that stabilize their value by being referenced to one dedicated fiat currency. So it comes quite close to real currency. And then the third group is kind of a catch-all basket. So it's other crypto assets. It's it may capture all types of crypto assets that do not fall under the first and the second category. So classic examples would be utility tokens. However, not such tokens which give you access to a good or service that already exists. So it looks into the future to fall under MiCA. And on the other hand, virtual currencies like Bitcoin or Ether is also qualified under MiCA. So on the right-hand side of the slide, you can see what definitely falls out of the scope of MiCA. So it's non-fungible tokens, which are very unique, like artworks, then classic e-money, and thirdly, security tokens that already qualify as financial instruments and fall under MiFID. So as Verena has also laid out, if any assets already fall under an existing regime, it is kept under that regime and not subject to MiCA now. If you would like to offer certain crypto assets to the public, you have to prepare a white paper. So this is similar or comparable to a prospectus under the prospectus regulations, but has a rather limited content. So in the annex of MiCA is laid out what needs to be included in the white paper. For example, information about the issuer, description about the offer, the rights and obligations attached to it, also the risks, the underlying technology, and what is quite interesting and important, the white paper also needs to include a disclaimer that it was not approved by a competent authority. So this is quite a huge difference, that you have to have a white paper. You also need to hand it in to the competent authority, but in general, it will not approved. There are also certain exemptions when you do not need to have a white paper. So for example, if the crypto assets are offered for free or they are automatically rewarded in the course of mining. There are also certain thresholds if those are not met. For example, if the consideration is $1 and less million, or if it is offered to less than 150 investors in one EU member state. In addition to the white paper, certain other aspects need to be considered when offering crypto assets to the public. So firstly, the marketing material. Also, the marketing communications need to be identifiable as such, and MiCA stipulates that it has to be fair, clear, and not misleading, and obviously it needs to be consistent with the information presented in the white paper. Also, this marketing communication can be assessed by the national competent authority, and they even have the right to request amendments or prohibit their use. Then it also comes with certain responsibility. So where the white paper contains misleading information, then the offerer or even the management is liable to holder of crypto assets for any loss incurred due to such misleading information. Of course, it's not able to circumvent that civil liability. So in case you try to exclude it in the white paper, this will obviously be null and void. And then also certain consumer protections are taken into account by MiCA. So we already know the right to withdrawal. Retail investors, they have the right to withdraw from the purchase within 40 days after the sale without any costs and importantly without any reasons. The withdrawal right does not apply where the crypto assets were admitted to trading on a trading platform. So how does the procedure look like? The white paper needs to be notified at least 20 days prior to its publication to the host national competent authority where the offer is established. Same goes for the marketing communication, and also a list of all member states needs to be provided where the offer will take place. As I've stated previously, no approval is needed. However, the home national competent authority will inform its point of contacts in the other countries, and they, together with ESMA, have certain intervention powers. So they even can request a stop of the marketing and, as I stated, request certain amendments. If they do not interfere, then the issuer and offerers can start promoting the crypto assets. However, on an ongoing basis, they have to comply with certain requirements. As I've also outlined in the very beginning, for stable coins, there is a certain bespoke and stricter regime. So stablecoins are both asset reference tokens and e-money tokens, and the group of issuers of those tokens is limited. So on the one hand, credit institutions and otherwise legal entities that are authorized under MiCA can issue such tokens, and e-money tokens can also be issued by e-money institutions. And then there are additional requirements like a strict obligation to maintain and the use of reserve assets, and also a certain capital requirements obligation and a clear policy for stabilization. And the investors, they have a direct right against the issuer to redeem their tokens for their value. Also, the white paper needs to be a little bit enhanced, so a stricter regime. And on top, the EBA is able to qualify certain stablecoins as significant stablecoins if they fulfill certain requirements. For example, they have a very high number of token holders or a high value. And if this is the case, then the EBA has certain direct supervisory powers in relation to the issuers of those stablecoins. And to continue with the regime applicable to the service providers, I may hand over now to Miroslav.
Thank you very much, Carmen. So we're gonna focus now on the harmonized rules on crypto asset service providers under MiCA regulation that are in many ways one of the most important parts of MiCA that we have been waiting for a long time. MiCA regulation creates a harmonized authorization framework for all entities providing regulated crypto asset services to EU residents. There is a long list of various crypto asset services under MiCA that will fall under the authorization regime. These are in many ways similar to the list of services that we can see, for instance, in the investment firms framework under MiFID II. So starting with some rather simpler types of services such as reception and transmission of client orders, execution of orders, placement of crypto assets, as well as regulated services around the provision of advice on regulated crypto assets, as well as portfolio management services. Further, we also have a second group of services that are comprised of crypto custody as well as exchange services. So either in fiat to crypto or crypto to fiat context. And the last category is the regulated service that applies to entities that operate a trading platform for crypto assets. As you can see on this slide, these three categories basically belong to three different baskets in terms of the own fund requirements, with the first requiring 50,000 euros of own capital, the second 125, and the third 150,000 euros. What do the entities aiming to provide crypto asset services need to do? They need to obtain an authorization from the national competent authority in the member state of their establishment. And for this purpose, they need to comply with a number of various requirements that are listed under MiCA framework and related legislation. So first, these are some standard requirements that we know from other subsectors of the financial services industry, such as standard organizational requirements, substance requirements, requirements around the safeguarding of clients' assets, compliance with certain information requirements when it comes to client agreements and marketing materials, as well as some more specific and technical processes and procedures. For instance, on the handling of clients' complaints, on management and avoidance of conflict of interest, as well as some service-specific requirements that are, for instance, specific to services like crypto custodies or service related to the operation of trading platform, where CASPs looking to operate trading platforms will need to comply with a number of quite detailed technical requirements that we know from the MiFID II framework that apply to operators of the trading venues. And last but not least, we also have a quite strict framework on outsourcing arrangements, as well as compliance with the new Digital Operation Resilience Act, DORA, that will apply to CASPs as well as of January next year. And this will be one specific part of MiCA that we usually draw our clients' attention to due to technical and operation complexity. On the next slide, we can see what this means in practical terms. So crypto asset service providers will need to be incorporated in the EU. They will need to have a registered office in the EU, and will obtain authorization from the NCA in the member state of their incorporation. Once authorized, they will be able, if they want to provide services across the EU based on a single license, either based on the freedom of services on a cross-border basis or the EU freedom of establishment, so through a branch opened in host member state. Practically speaking, this means that CASPs will need to ensure that their legal entity in the EU is the place of their effective management. So members of the management board will need to be there, and the majority of most important decisions will need to be made in the EU. CASPs will also need to ensure that the members, the candidates for their management board, will need to be persons that are suitable and reputable enough to exercise such function. Also, in addition to members of the management board, CASPs will also need to ensure that they hire competent and suitable staff that will be responsible for key control functions, such as, for instance, head of compliance, head of risk management, internal audit, and so on. As mentioned earlier, compliance with the outsourcing framework, so with requirements applying to outsourcing arrangements that will probably be very important for CASPs that will most likely be rather smaller entities that will not be able to perform all their internal functions on their own, will be another very important milestone in this process, as well as compliance with new DORA requirements on management of ICT risks and ICT governance. This all, basically this compliance with the number of various regulatory requirements will need to be demonstrated by CASPs first in writing in their policies, but as well as in some operational parts of their internal process. So internal processes, procedures that are aligned with the described compliance in their policies. And last but not least, MiCA also contains a specific part that addresses the prevention of market abuse that in many ways replicates the regulatory requirements on the prevention of market abuse that we know from the market abuse regulation. When it comes to entities that are already now providing crypto asset services in the EU or financial institutions, the EU lawmaker has created a easier process for them to get aligned with the new framework. So first, when it comes to entities that are regulated under national framework, for instance, like CASPs currently operating in Germany under German law, member states will be able to basically grant them the possibility to apply for a so-called fast-track application. So for instance, in this case, member states can, in their national transposition laws that are not required, but many will opt to do so, basically create a special framework for authorized CASPs, which, for instance, the German lawmaker has already done, and we're going to come to that a bit later. So this means, practically speaking, that, for instance, institutions that are regulated under the German Banking Act, KVG, at the moment will be able to apply for a fast-track procedure, just as part of which they will need to prove to German BaFin that they comply with MiCA requirements based on their existing processes, policies, and procedures. And when it comes to financial institutions, conscious of the fact that MiCA framework is rather less complex than regulatory frameworks applying to investment firms and credit institutions, the EU lawmaker has left the possibility for regulated financial institutions to provide crypto asset services based on their existing licenses, provided and conditional upon notification of their national competent authorities beforehand. So, for instance, if we just take, for example, MiFID II investment firms, the EU lawmaker has left the possibility for them to provide crypto asset services that are in nature very similar to services that they are already authorized to do. So, for instance, reception and transmission of client orders instead of solely in relation to financial instruments will now be also possible in relation to crypto assets, exchange services, operation of trading venues or trading platforms in this context, and so on. E-money institutions will also be able to provide services that are inherently very similar to those that they do as part of their day-to-day business, such as custody and transfer services for e-money tokens in particular. And when it comes to credit institutions, they will by far have the greatest freedom to provide all crypto asset related services defined under MiCA. On the next slide, we can see basically summarized how the authorization procedure for CASPs will look like. In the first steps, prospective CASPs will need to submit the application together with the supporting documentation. So, for instance, the aforementioned policies, the regulatory technical standards published by ESMA in accordance with Article 62 of MiCA. They provide a lot of detail when it comes to exact content of the application package and the process. What is important to be mentioned here is that what the prospective CASPs need to have in mind is that as part of this application process, they will also need to complete the so-called ownership control procedure that is part of any application procedure under other sector-specific regulations, which usually requires a lot of time and effort, especially when it comes to CASPs that have a rather longer cap table with various venture capital funds or angel investors on board, given that a lot of documentation needs to be submitted to the NCAs. Within 25 working days, NCAs basically have obligation to assess the completeness of the application. And following the notification of completeness, basically the clock starts running. What this means is that within 40 working days as of this date, the NCAs are required to assess and decide on application. And provided that permission is granted, the entity can start operating in the EU. When it comes to location and the geographical spread of the service offering, as mentioned before, it will be possible for CASPs to benefit from the so-called EU passport. And if not submitted at the point of application, CASPs can submit the passporting application to their NCAs later on. This is a very simple notification process during which basically the NCAs need to be made aware of all EU member states where prospective CASPs want to provide their services. And basically following this, the home NCA will perform notification at the NCA level. So it will communicate this with all NCAs in the EU where the CASP wants to provide its services. And following this, basically, it is possible to provide services on a cross-border basis. Moving forward, and now given that we are edging ever closer to the go-live dates for MiCA, many are asking themselves, where do we stand with the Level 2 and Level 3 acts that are desperately, that many of us have been desperately waiting in the last 4 years, given that they specify in detail some high-level requirements from MiCA regulation. So here in the table on the left-hand side of the slide, you can see 3 packages of RTS and Level 3 legislation that ESMA has published, with the first consultation package from July, the second from October last year, and the third published just a month ago. The first consultation package is already finalized. The final report was published on 25th of March, whereas the second and consultation package are to be finalized by June and December this year, respectively. Now, in addition to these 3 consultation packages of ESMA, there are also 3 consultation packages of EBA. EBA packages, they focus on the issuers of stablecoins, and they have been likewise published in July, October last year, and they are partially finalized. Especially the first package was finalized already. When it comes to ESMA packages here, so what this means, practically speaking, what they brought to the market, well, they brought some clarity, especially if we talk about the part that Carmen just explained to you when it comes to issuers and the public offerings of crypto assets. They provided clarity on the exact content of the white paper. For instance, when it comes to CASPs, as mentioned before, the application for authorization, the content, and the process. As well as some more acute, so to say, parts of MiCA that needed further clarification, such as technical requirements around the detection and reporting of market abuse, so the technical part of the compliance, as well as procedures on the conflict of interest management, complaints handling processes and procedure, as well as ICT compliance, so compliance with Digital Operational Resilience Act for CASPs. Operators of trading venues, in particular, have benefited from some further clarification in the RTS around the trade transparency that are in many ways following the regulatory requirements and transparency that we know from the MiFID II world. And there were also some very helpful clarification on the aforementioned ownership control process. So in cases where you are either setting up a CASP or where you basically are bringing new investors on board that are acquiring qualifying holdings in an existing CASP. Out of all of these level 2 and level 3 acts, we just wanted to take a sample, two samples basically of two very, very important clarification points. The first one is the so-called reverse solicitation. Reverse solicitation is something that we know from especially MiFID II and credit institutions framework that basically grant, so to say, passive freedom to non-EU entities to provide regulated financial services to EU residents without the need for an EU license. Conscious of this possibility in other sector-specific regulations, the EU lawmaker has embedded in Article 61 MiCA this possibility. So basically for non-EU CASPs and non-EU unregulated institutions, basically to benefit from this passive freedom. However, it needs to be mentioned that this is a very, very narrow possibility, and therefore the Commission has originally asked ESMA to clarify the scope of this reverse solicitation framework. In MiCA, we just had a very simple sentence that where a third country firm provides crypto asset services at the exclusive initiative of the EU customers, license obligation will not apply. However, there were a lot of related questions that needed some further clarification. And here on the left-hand side of the slide, you can see that basically reverse solicitation basically enables non-EU entities to provide regulated service to an EU resident at their exclusive initiative. So, for instance, when an EU resident goes to the website of a foreign offerer, but this foreign offerer is not promoting its activities in the EU. So this is basically what this passive freedom means. There are also some additional limitations now here. So, for instance, if we look at some standard scenarios that we can have in this context, is okay. The question was, what happens if a non-EU firm wants to offer other assets in the course of a phone conversation or email correspondence? Is it allowed to do that or not? ESMA has clarified that non-EU firms are able, so in the course of the conversation with the client, to offer them other comparable assets. So if the conversation is being underway around the utility tokens or stable coins, the firm can offer to this customer the other utility or a stable coin. And another question was around the follow-ups. So if we have, for instance, today email correspondence or a phone call around the provision of certain service by, let's say, a UK firm, whether this UK firm can reach out again and offer me some additional services. ESMA has set the maximum period for follow-ups is basically 1 month as of the day of initial contact request that was made by the customer. And on the right-hand side, we can see what are some red flags and no-goes. So in all of these cases, license obligation will be triggered. So for instance, if non-EU firms solicit in any way whatsoever, real-time or not, EU customers by sending promotional offers, documents, marketing communications, and so on and so on. It has a very, very broad scope, especially nowadays when we have a lot of influencers and even persons that are promoting certain offers and crypto asset service providers without being even engaged to do so. This can also trigger a solicitation threshold for non-EU CASP, which is something that will require additional attention of non-EU firms that will need to manage their relationships with external promoters and persons promoting their products and services, especially on social media. And as you can see also in the last point, the scope of the promotion per se is also very, very broad. It can capture anything. So in writing promotions via social media, banner advertisements, even sponsorship deals. So for instance, something that we saw in the past couple of years, where foreign offers and issuers of crypto assets have been sponsors of certain sports clubs and so on and so on. This will no longer basically be possible. And the second one is the ESMA guidelines published on 29th of January this year on basically distinction between the scope of application of crypto assets framework under MiCA and financial instruments framework under MiFID II. In these guidelines, ESMA has basically analyzed 5 different scenarios. So first, what are some points of differentiation and when can crypto asset qualify as a transferable security under MiFID II? Here, ESMA has basically repeated some criteria that has listed in some previous advices that basically can be summarized as follows. So crypto asset that qualifies as transferable security is basically an instrument that is part of a class of securities, let's say a bond or equities, that is negotiable on a market, capital market, but it has been clarified that this can also capture a crypto platform. And the most important criteria is basically that the crypto asset is granting rights similar to, for instance, other transferable securities such as shares, bonds, or securitized derivatives. Crypto assets can also qualify as unit investment funds if they basically fall under the national definition of a collective investment undertaking. So basically, if someone is pooling investors' assets by selling the coins with the intention to invest them for profit and the benefit of investors, in this case, token holders. When it comes to derivatives and money market instruments, it is also fairly simple here. So MiFID II, in Annex 1, Section C, we have quite a long catalog of various derivative instruments, and ESMA has clarified that crypto asset can be a derivative instrument where it is basically in a standard way, like any other derivative, a digital representation of a contract, like a future, forward, or an option, and that has an underlying reference that is basically determining its value. And the fourth scenario here was also whether a crypto asset can qualify as a money market instrument. This is probably one of the rarest cases, but at the same time, one of the simplest ones, because basically any crypto asset that functions as a debt instrument and that has maturity lower than 397 days would fall under the definition of a money market instrument. When it comes to emission allowances, this is also a case which really doesn't happen in practice that much, given that the emission allowances are certificates that basically permit their holders to emit specific amounts of greenhouse gases, not that relevant for the crypto industry. And what we see in practice is that crypto assets are more commonly similar to, for instance, carbon credits rather than emission allowances. And if we look at the MiCA framework in a cross-border context, just very briefly, so based on everything what Carmen and I just explained, if we look at the offering of crypto assets, let's say in the UK-EU context, if you are an issuer or offerer in the UK, when it comes to stable coins, you cannot offer stable coins to EU residents because under MiCA framework, issuers of EMTs and RTs need to be EU persons. When it comes to other crypto assets, this is generally possible, provided that you comply with notification requirements on white paper and marketing communications. And the member state where this notification needs to be made is in most cases. So if you don't have any branch or establishment in the EU, the first EU country where the offering takes place. When it comes to provision of services, as mentioned before, reverse solicitation is a very, very, very narrow possibility that hardly anyone can rely on if you want to have a proper, solid footprint in the EU market. This practically means that the UK headquarter for EU EEA businesses is rather not an option. And entities looking to have presence in the EU will simply need to have an EU subsidiary that will operate in compliance with local requirements. Now we're going to have take a brief look at some key developments in Germany and Austria. I'm just going to kick off now with some latest developments in Germany. So in Germany at the moment, we have an existing regulatory framework on crypto assets that is pretty much MiFID-like. Framework that regulates a variety of regulated services in relation to crypto assets. German lawmaker has done this originally in 2020 by basically just bringing crypto asset services under the scope of the existing regulations under the German Banking Act. So for instance, investment intermediation is regulated, proprietary dealing, principal brokerage, and so on, as well as one special service, crypto custody business, that is in many ways similar to crypto custody as defined under MiCA framework. In October last year, the German Federal Ministry of Finance has published one draft act on digitalization of the financial markets in Germany. And as part of this act, the German lawmaker has also introduced some changes that are aimed to align the existing framework with the MiCA framework. In April this year, Ministry also published some further clarifications in the regulation on transition of the existing legal framework to MiCA framework, as part of which the fast track procedure that we mentioned earlier was clarified in more detail. So what happened here? We had a definition, when we have a definition in the German Banking Act of regulated crypto assets, that will now be totally replaced with just a reference to MiCA definition, aiming to provide harmonization and clarity at the EU level as well. But at the same time, the German lawmaker has created a new category of crypto assets, which is almost entirely based on the existing definition of crypto assets under the German Banking Act. So basically, this will be digital assets that do not qualify as crypto assets under MiCA, but also do not qualify as crypto securities, so transferable securities in terms of the EU legislation, but crypto securities and crypto fund units in within the meaning of applicable German rules. What is the point of this last category is basically to cover any digital assets that will fall somewhere in between. So between MiCA framework and the old German rules, with the aim of circumventing any loopholes in this transitional framework. The lawmaker has also introduced a new activity, the so-called qualified crypto custody business, that will cover the safekeeping of this new category of crypto assets. So safeguarding of MiCA crypto assets will be regulated under MiCA framework, but safeguarding of this new category, cryptographic instruments, will be regulated under the new within the new framework. And we can see here on this slide basically summarized. So if you compare crypto assets regulation, so MiCA regulation with the new rules under German transitional law, is basically that on the left-hand side, we can see types of assets that will be covered under MiCA, and on the right-hand side, we can see two classic examples that the German lawmaker wanted to cover with this new type of crypto assets, cryptographic instruments, that could be, for instance, security tokens that qualify as financial instruments under MiFID II, but that do not qualify as securities under within the meaning of the German Electronic Securities Act. This can also be the case for certain types of non-fungible tokens, because if we remember NFTs that are issued as part of collection or series, they can fall under the scope of MiCA. But for instance, some NFTs that are not issued as part of collection, but still could fall under the German law by virtue of the fact that they have certain investment purpose, would fall under this new category. And when it comes to custody, as mentioned before, standard custody will be regulated for crypto assets under MiCA, and qualified crypto custody will apply to this new type of crypto assets. And now I'm going to hand over back to Carmen, that will run you through some developments in Austria.
Exactly, thank you. For Austria, one slide is sufficient. Because in Austria, at the moment, we do not have a dedicated regulatory framework for crypto assets. The only instance in which there is a definition of virtual currency is for AML purposes in the Financial Markets Anti-Money Laundering Act. However, it can, of course, be the case that if certain criteria are fulfilled, the assets fall within the scope of the Austrian securities law or need an authorization under the Austrian Banking Act or the Austrian Payment Services Act. And in case derivatives reference cryptocurrencies, they will, of course, be qualified as financial instruments under MiFID. So far, there is not that much. However, the Austrian Market Financial Authority, the FMA, which is the correspondent of BaFin in Germany, they are already preparing themselves for MiCA. So they expect, once corresponding national legislation is introduced, that they will obviously be the national competent authority. They will be responsible for processing license applications and taking into account reports and handling everything related to MiCA. And in order to prepare itself for those new responsibilities, you can already see on the FMA homepage certain information material, and also they are they are willing to already conduct informal discussions with prospective licensees in order that once MiCA is in place or is applicable, then the licensee can apply quite swiftly and everything kicks off smoothly. The way ahead.
Well, let's for the few last minutes take a look what to do if we want to become a crypto asset service provider. We have drawn an implementation roadmap which makes sense in lots of license applications. So first, you need to identify the regulated services you intend to provide. You need to also find a EU member state where you want your headquarter to be. Yeah, can be Germany, can be Austria. Austria is very fintech friendly at the moment. So yeah, can be Ireland, can be another one. So please think about what suits your business quite well, and also select a core team and support staff for this roadmap, because it's quite a lot of work. If you are already regulated, you already know that it is a little bit of a road ahead. Then you have to conduct a gap analysis and see what new requirements there are for compliance. You have to set up the governance and adequate governance and internal control structure of your new entity. If you are completely new to this, yeah, then you can start from scratch. Sometimes it's a bit easier to start from scratch. Yeah, you have to identify your key stakeholder, control functions, internal vendors. You also have to already think about DORA, because this is lots of digital things. So DORA comes on top of this new regulation as well. So it's a lot of paperwork. policies, contracts, internal processes also need to be documented. You need to prepare for your ownership control procedure, which is always a burden in all EU member states. It's not only in Germany. And you have to prepare your license application. But if you do the rest of the paperwork, the license application is basically the business case and the forecast of your business numbers and so on. That's fine. A huge part will be the policies, the contracts, and the internal governance structure. Yeah, that will be the main part. So, and once you have obtained your license, if you are already regulated, you know, it's not the end, it's a start, but you also need to ensure continuous compliance as well. But life gets easier once you have a license, definitely. So, and here we have, as always on our last slide, some practical considerations. If you are thinking about entering the crypto asset regulatory space under MiCA, we would recommend to stay up to date. The ESAs still need to finalize a number of RTSs and guidelines in the coming months. This will give a lot of more guidance. Yeah, if you are already regulated, try to talk to your regulator and try to see what they are communicating. And you also need to dedicate sufficient time and also resources for the implementation of new requirements. This is also something you cannot really do this with one person on the side. That's not working. Yeah, and now I'm just repeating myself. So if you are already regulated, make use of what you already have. You can leverage the existing processes, procedures, also the documentation. And once you have done a gap analysis, you will know what you have to do, draw up additionally. Yeah. As Miroslav also already said, the compliance with new requirements is not the same as compliance with the existing framework. It is different. It's also meant to be different because it's a different kind of business and different assets, different kinds of assets. So yeah, be aware here, please, and start as early as possible. I think this holds true for any new requirements. So this was the overview on MiCA, and now we have some questions. So Miroslav already answered some of the questions here in the chat, but some questions are quite interesting, so I will try to read some, and then Miroslav, you can maybe answer those as well, so everyone know. So one question was, financial instruments do not fall under MiCA. If they do not fall under MiCA, how does this go hand in hand with German BaFin categorizing Bitcoins as Recheneinheit, or does MiCA overdrive this banking act categories? Miroslav.
Sorry, so the one on the German framework, this was very interesting to hear. Yeah, so under the existing German law, crypto assets defined under German Banking Act are defined as financial instruments. However, with the aim of aligning the existing framework with MiCA, that does not recognize crypto assets as financial instruments, the German lawmaker has basically deleted regulated crypto assets from the list of regulated financial instruments under German Banking Act, and basically now this new definition of crypto assets that only contains a reference to MiCA will no longer be on the list of regulated instruments.
Yeah, excellent. And we have one other question. In which areas do you see the need for established market participants in traditional assets such as banks, exchanges, custodians, and also asset managers to adopt their operations under MiCA? I think it's also a question everyone will be interested in.
Yeah, I just briefly texted on that. So basically, generally internal processes and procedures of incumbent financial institutions are way more complex than the ones that NCS expect to see um, uh, by the CASPs. However, if we take, for example, an existing investment firm as an example, there will be some need for alignment, especially when it comes to consideration of specific features of crypto assets. So let's say, for instance, in terms of liquidity or risk management, right? So you cannot run the existing, you cannot manage risks related to crypto assets based on your existing risk matrices that take into consideration rather different market credit and liquidity risks. This would be some one of the areas, as well as of course procedures on safeguarding of digital assets, for instance. So especially when it comes to technical infrastructure processes and so on, where you need to rely on different type of external vendors or develop your own IT infrastructure internally, which probably not that many financial institutions will do. If we talk about the external vendors, naturally equivalent management of outsourcing risks and third-party risks would be also an additional point that that incumbent financial institutions will need to consider.
Yes, thank you, Miroslav. Then we have a remark that BaFin is not so forthcoming at the moment. That is also our impression. We really hope, and we also believe that BaFin will actually need to keep up at the moment with the market. We have lots of business driven to Austria and to Ireland at the moment. Yeah, I think they will have to wake up eventually. So yeah, because otherwise it would not be good economically for Germany. I can understand this this remark. We also see this, and we are also a bit worried. Yeah, we'll see. So I still hope we will get to it eventually. Yes, and then there was another question for the last minute. I can also quite share how's the situation in UK, since UK is not part of the EU anymore. UK is developing their own regulatory framework on crypto assets, will be slightly different to the EU framework. Yeah, and it's a slightly different approach. Yeah, so, and as in all other sections as well, so if you get a MiCA license in Europe, you will not be able to passport to the UK, and also vice versa. It does not work. Okay, that's it. Time is up. I think we have also answered all the questions. Let's stay in touch. If you have any questions, you can also always reach out informally to us. We are always happy to talk and discuss issues. We'll probably have another MiCA webinar once we have more guidelines from the ESAs. Yes, later this year. And so thank you very much for joining and for staying and listening and all your questions. And then have a lovely week, and let's stay in touch. Bye.
Thank you. Bye-bye.
Thank you.